unfair labor practice. Okay, what the labor practices which are not fair. Okay, in Industrial Disputes Act under section 2RA, it is said that any practice specified in fifth schedule is an unfair labor practice. Okay, in fifth schedule there are two categories, category 1, category 2. In category 1 there are 16 practices which, if done by employer or their trade unions, are called unfair labor practices. Or in category 2 there are 8 practices. If these practices are done by workmen or their trade unions, they are unfair labor practices. Section 25 says no employer or workman shall commit these unfair labor practices. Section 25U says if they commit these unfair labor practices, then there will be 6 months imprisonment or a fine of rupees 1000 or both. First come to category 1. Okay, the unfair labor practices performed by employer or their trade unions. Okay, what are these? If an employer interferes with, refrain from, or coerce workmen in exercise of their right to organize, form, join, or assist a trade union, or to engage in concerted activities for purpose of collective bargaining. Okay, the workers have the right to organize, form, join, or assist trade unions. Okay, if they want to exercise this right and the employer interferes with this right or refrains them from exercising these rights or coerce the workmen in exercise of their right, then it's unfair labor practices. Or for the purpose of collective bargaining, if the workmen are engaged in concerted activities, okay, then if the employer interferes with it or refrains from or coerces the workmen, then also it's unfair labor practices. Okay, if a employer dominates or interferes with or contributes to any trade union by supporting financially or otherwise, then also it's an unfair labor practice. The if the employer establishes, okay, to establish employer supported trade unions of workmen, the employer cannot establish employer supported trade unions. Okay, it is an unfair labor practice. Or to encourage or discourage membership in any trade union by discrimination against workmen. Okay, if an employer encourages or discourages membership in any trade union by discriminating against any workmen, it is also a unfair labor practice. To discharge or dismiss workmen by way of victimization means singling out and oppressing. Okay, to single out some one person, any person, and then oppressing him. Or discharge or dismiss him by falsely implicating the workman in a criminal case on false or concocted evidence, or by discharging or dismissing him on untrue or trumped up allegations of absence without leave, or to discharge or dismiss the workman for misconduct of any minor or technical nature. If a workman does any misconduct which is not of major nature or which is very minor or technical nature, and to dismiss or discharge him on that basis, it is also unfair labor practice. To abolish work of regular nature being done by workmen and to give such work to contractors as a measure to break the strike. Okay, while the workmen are on a strike, the employer abolishes their regular nature, the work of their regular nature. Okay, and to give that work to contractors, it is a unfair labor practice. To transfer a workman malified from one place to another under the guise of following management policy. Okay, to insist workmen on legal strike to sign a good conduct bond as a precondition to allow them to resume work. Okay, to show favoritism or partiality to one set of workers regardless of merit. Without merit, if he is doing favoritism or partiality to any set of worker, it is unfair labor practice. To employ workmen as badlis, casuals, or temporaries and to continue them as such for years. The objective is to deprive them of status and privileges of permanent workmen. Okay, what are badlis? If there is a permanent workman and he is absent for some time, then to appoint some another person in place of him, he's called badli. Okay, that person who is appointed now, he's called badli. So to employ badlis and temporaries and casuals and to continue with them for years so that they do not get the status and privileges of permanent workmen. This is unfair labor practice. To discourage to discharge or discriminate for filing charges or testifying against employer. If some workman files charges or testifies against an employer for an industrial dispute proceeding or any other proceeding, so for this he discharges or dismisses or removes the workman, or to discriminate against him, it comes under unfair labor practice. To recruit workmen during a legal strike, if there is a legal strike going on and the employer recruits some workmen, it comes under unfair labor practice. Failure to implement award, settlement, or agreement. If there is any award or decision of a labor court or settlement or agreement done by the any board or conciliation officer, and the failure to implement it comes under unfair labor practice. To indulge in acts of violence or force, refuse to bargain collectively in good faith with recognized trade unions, all these comes under unfair labor practices. Or to proposing or continuing a lockout deemed to be illegal. If there is a lockout which is illegal, if the employer proposes it or continues with the illegal lockout, it comes under unfair labor practices. Now comes category 2, which are unfair labor practices by workmen or their trade unions. So what are these? To advise or actively support or instigate a strike deemed to be illegal. If there is a strike which is deemed to be illegal, if the workmen advise for it or actively support it or instigate it, it comes under unfair labor practice. To coerce other workmen in the exercise of their right to self-organization, join a trade union, or to refrain them from joining any trade union. Okay, to coerce workmen in the exercise of their right to self-organization, or to coerce workmen to join any trade union, to force them to join any trade union, or to force them to refrain from joining any trade union, it comes under unfair labor practice. To indulge in acts of violence or force, okay, for a recognized union, to refuse to bargain collectively in good faith with employer, okay, it also comes under unfair labor practices. To indulge in coercive activities against certification of bargaining representative, to stage, encourage, or instigate such forms of coercive actions as willful go slow squatting on the work premises after working hours. After working hours, they kind of illegally occupy the work premises or gherav any member of the management or other staff. It is also unfair labor practice. To stage demonstrations at the residences of employer or management, to incite or indulge in willful damage to employer's property connected with the industry, or threats of intimidation against any workman with a view to prevent him from attending work. These all come under unfair labor practices by workmen or their trade unions. Okay. If for revision you want this PDF, the link will be in description box or comment box. Next topic will be collective bargaining, which we will cover in next video.